Hello, hi. We want to look at this topic of patents and specifically in relation to software and whether or not would software be something that can be patented. You find that there are different legal positions taken in different parts of the world, and so we want to see what is that legal position for UK. Now, the starting point, of course, is the Patents Act 1977, where by virtue of Section 1, Subsection 2, Subsection D, it lays down a list of items or subject matter that is prohibited from being patented. And it lists down a computer program as one of those things that cannot be patented. And it says it can't be patented as such. And by as such, which I highlight for you, it indicates that you can't patent it as it is. So in as much as, for example, you can't patent a discovery as it is. Say, for example, Isaac Newton discovered gravity. You can't patent gravity as it is. You can't patent a computer program as it is, as such. But obviously, if you can find a way as to how to put that invention or that discovery into effect, not as such, not as it is, then perhaps you can patent. So therefore now that we have this very interesting question, which is where we want to examine when is it that a patent may not be caught by the exclusion in 11D. What does the law say in UK on perhaps any exceptions as to when it falls outside the patentability of the software as such? And so a starting point would be the case of Aerotel and Macrosan, where this case lays down for us a structured approach, a step-by-step, four-step approach as to whether or not may software be patented. And the first step is where we have to look at the patent claim itself and to construe it to see what it says, and where we want to identify the contribution that it has been indicated within the patent claim to delineate exactly what is it that is being claimed, and see from there whether it is something for which it falls within excluded subject matter. In this case, whether does it fall within the definition of a computer program. And when it does, then they ask the last question, which really is the most important question, where we want to ask now, does the particular computer program has a technical effect? Whether the so-called contribution is it one for which is technical in nature. And so this is actually currently the approach taken by the UK IP Office and represents now the so-called gold standard, or represents now the law as to whether or not would a computer program be patented. And this will be the final question, the fourth step or the fourth approach or fourth structure, being the most important that one has to examine to ask whether would the contribution made by the computer program be one for which has a technical effect. Now you must appreciate that step 1, 2, and 3 are just steps in a sense. It guides you to arriving at the fourth question. The fourth question is the one that's most important in arriving and asking whether or not is the contribution technical, and if so, therefore the computer program is one that you can patent. So let's now look at some cases, in particular the cases of Aerotel and Macrosan, and we want to see whether are we able to identify whether on the particular facts of those cases is there a technical contribution. Starting of course with the facts and case of Aerotel itself, you find here would be a case involving a computer program that involves the making of a phone call, in that the technical contribution allegedly is the fact that you can use a local phone call, and by keying in a PIN code or password as such, it allows you now to make international phone calls and be charged locally. And so whether or not if this is what the computer program does, so allowing someone to make a local phone call but yet be able to reach international countries and be paying local charges, would this be an invention, a program that has a technical effect? In comparison, let's look at the case of MacroSend first. When MacroSend, this was a case concerning an invention that allows for an automation of the incorporation of a company. Where in the case of MacroSend, this was how this particular program would allow for users to submit documents, to verify those documents as correct ones, and then through that automated process or promptings that may go back and forth, eventually allow for a company to be incorporated fully online. There's no need for now the user, for example, to go down to any office physically to submit documents. It's just done online. They ask for your, say, company documents, the company constitution. They ask for your IC, for example. These are all things for which that can be submitted online. And upon receipt, it then prompts you further for any required information. And that's it. You have your company incorporated. So which one would you think is it that achieves this technical contribution? And so if you have chosen the case of MacroSend, that's right, that's not the answer, that's the wrong answer. Whereas in AeroTel, that's the case where the court found that there is a technical contribution. So you find that these two cases, when you compare them, does to some extent give us an idea of what it means by technical contribution. So by way of clarity, if you were to look at the case of MacroSend, really essentially MacroSend does not do anything new in a technical sense. It's really something for which that could have been done by someone by submitting documents via email, for instance, but just now it's an automated process. Whereas in the case of AeroTel, that's different. AeroTel is where you are making a local phone call, but yet the program is such that it can, due to the routing of the phone call through different servers, make it such that you end up making a local phone call, but yet to an international destination. So that's why the court found that this was something technical or new, and hence it satisfies this test. And it was AeroTel where in the case that the computer program was allowed to be patented. Now, post AeroTel and MacroSend, there are of course numerous cases, but I want to just choose one case for now to be discussed, and that is the case of Symbian. And the case of Symbian was a case where the court recognized the difficulty in identifying whether or not would a computer program be something that would be patented or would it be excluded. And so, for example, if just now you had difficulty in assessing or in arriving at the correct answer, you and good company, even the judges themselves acknowledge that it's not an easy question. And in fact, the judge went on to say that one ought not have very rigid prescribed rules due to the fact that there is changing technology all the time, that it's virtually impossible for us to set out an exhaustive, definitive guideline as to what is or is not technical. So one ought not to be rigid in approaching this. And in fact, they say that it is to be decided on a case-to-case basis, based on the particular facts of each case, then maybe or maybe not that there is a technical contribution. Now, what is interesting about Symbian's case is this, that in this case, the court was looking at whether or not can there be a technical effect when the so-called alleged contribution or effect operates within the computer itself. Now, obviously, if this is a computer program that does something outside the hardware, externally in a sense, where for instance, this could be a computer program that could cause a drone to fly, to cause a robot to run, for example, then I think that's very clear that there is a very technical effect achieved by the computer program. But Symbian is a case that deals with where the so-called effect operated within the computer itself. And so whether or not can this still be said to be technical. So let's look at now the effects of Symbian, and let's also have this simple exercise to examine whether or not is this something that may amount to a technical contribution. And so the effects of Symbian was this, where it involved this particular program that improved the reliability of an online library. These were all related linked libraries. It's a huge database of materials which could be accessed by users all over the world, where they could make big changes. They could extract information concurrently, all accessing these huge related linked libraries. Obviously, you can imagine that this is a library for which might be slow, because if I would update it at my end, you may only see it maybe a bit later. And if there are concurrent users logging in, it may cause the system to conflict or to crash. And so that was the particular problem that they faced back then. And the technical contribution, allegedly, that in Symbian, it contributed to the library or to the computer program in question, was such that it enhanced the whole system to make it more reliable, to avoid crashes or malfunctioning, and in fact made it use less memory in the computer. So based on the facts that you see here before on the screen, would you think that this will have a technical contribution? And that's right, here was a case where the court said that it was patentable, even though the technical effect was occurring within the computer. Now, in Symbian's case itself, just to summarize the key points which I've extracted from the judgment, the court is saying that if it solves a technical problem external to computer or solves one within the computer, that makes the computer program one that you can patent. And if it leads to a more reliable computer, that itself is also something that achieves a technical effect. And finally, the reliability could be such that it makes the computer run faster, it's improved, it solves a problem previously. This will make the computer program to be patentable, because right now you're no longer patenting the computer program as such or as it is. Now, obviously, we do acknowledge that it is difficult, it is uncertain exactly what kind of technical effect is required. And although we do say that it's on a case-to-case basis, although in Symbian itself, the court had provided fairly useful guidelines, but that is just on the particular facts of Symbian. So how do we really know when is it that a computer program has a technical effect? And along comes now AT&T, the case, which has been affirmed in the case of HTC and Apple. And the usefulness of this case is where the judge laid down 5 guidelines or 5 signposts. These were all drawn from previous cases, and so we won't go through all the earlier cases, but it's all now summarized here in some sense in the case of AT&T, what we today know as the AT&T signposts. And the signposts are as follows. So for example, here is where we look at whether or not does it have an effect on a process which is carried on outside the computer. This was my earlier example where I said that if this computer program were to make a device do something, it is operating external or outside the program itself, it makes a drone fly, for example, then yes, that would be such that it has a technical contribution. Now, of course, in Symbian's case itself, where the effect is within the level of architecture at the software language itself, and it makes it to be better, then therefore this could make the computer program one that you can patent. Thirdly, of course, is that it makes the program to operate in a new way, something for which you could not have done before previously or even manually, but the program allows you to do that, then yes, that would be such that it makes the computer to be patentable. But 4, this would be where it makes the program to be better, more efficient or more effective. So the 5th signpost would be whether or not would the computer program be able to overcome either an actual or perceived problem. Now this is as opposed to merely circumnavigating a problem. So if the program in question is able to solve a problem or to overcome the problem, then this will be an indication that the computer program has a technical effect and can be patented. So overall, you are seeing here where there are 5 what we call AT&T signposts from the name of the case AT&T, and they are so-called signposts in that they are indicative of whether or not the computer program can be said to have a technical contribution. And the moment it has that, that's it, then this will be a computer program that you can patent. The most recent development is this case called Lantana, and Lantana Limited is a case involving the following facts. And we also want to see now whether or not this program can it be something that you can patent. The facts involve this particular program where it allows for retrieval of data from a remote station. And so the user, for instance, will make a request for documents or data, and it results now in certain emails being generated automatically that will extract data from a server. And then this data will then be remitted over to the user, right? So this is this program now, literally where it is a remote computer that allows for machine readable instructions to be received, to be processed, and then to comply with what was instructed or what was required to retrieve and send back the data. So what about this program? Would you think that this program has a technical contribution? If you've answered no, then you're right, right? Here was a court found that no, this is not a software that can be patented because there's nothing new, there's no technical effect that's been achieved. It's again very similar, really, if you think about it, to the case of MacroSend, where it was an automated system of incorporating a company. Here is, in some sense, an automated method of retrieving data, and in both cases, I think it's fairly similar. And so, if you had got the case of MacroSend earlier on correct, by analogy or by extension, likewise in this case, the court will also come to that same conclusion, which they did, that the program itself cannot be patented. And so what do we have now? How do we determine whether a computer program or software can be something that you can patent? You find that the uncertainty still lingers on. Despite the AT&T signposts, which useful though it may be, it remains to be seen really how in future cases that this may or may not be patented. And so to the question of what is of a technical contribution, judges themselves have commented frequently that they themselves find this to be a difficult question. And so you are in good company if you yourself find that you cannot determine exactly what is of technical contribution, because the UK judges themselves have had great difficulty in this area as well.